Hello and welcome to TaxPundit. The case under discussion is Rajvir Singh versus Deputy Commissioner of Income Tax, Agra Tribunal, pronounced on 22 June 2026. The case involves Shri Rajvir Singh, who filed his original income tax return under Section 139 for assessment year 2016-17 on 14 January 2017. Later, the assessing officer issued a notice under Section 148 to reopen the assessment. In response, the assessee specifically requested, via a letter dated 17 March 2022, that his original return be treated as the return filed in response to the Section 148 notice. However, the assessing officer completed the assessment under Section 147 read with Section 144B on 29 February 2022 without ever issuing a notice under Section 143(2). This omission became the central legal issue. After the assessment order was passed, the assessee challenged it before the Commissioner of Income Tax, Appeals, National Faceless Appeal Centre, which confirmed the order on 15 September 2025. Aggrieved, the assessee appealed to the ITAT Agra bench, though there was a 40-day delay in filing. The tribunal condoned the delay, finding reasonable cause. Crucially, the assessee raised an additional ground, a purely legal issue, that the failure to issue the mandatory notice under Section 143(2) rendered the entire reassessment proceedings void. The ITAT first addressed whether the additional ground was admissible. Since the issue was purely legal, whether the assessing officer had jurisdiction to pass the order without issuing a Section 143(2) notice and did not require any new facts, the tribunal admitted it under Rule 11 of the Income Tax Appellate Tribunal Rules, following the Supreme Court's decision in NTPC Limited versus CIT. Both the Assessee's Counsel and the Revenue's senior departmental representative agreed that the ground was legal in nature, so the ITAT proceeded to hear it on merits. The assessee argued that his case was identical to that of his wife, Srimati Prem Lata Verma, whose appeal had already been decided by the same ITAT Agra bench. In the Prem Lata Verma case, the assessee had also filed a Section 139 return and later requested that it be treated as a return under Section 148. The assessing officer did not issue a Section 143(2) notice there either, and the tribunal quashed the assessment. The assessee submitted that the same reasoning should apply to his case. The core legal principle comes from the Supreme Court's landmark judgment in Assessee versus Hotel Blue Moon. The apex court held that the requirement to issue a notice under Section 143(2) is not a mere procedural formality. It is a mandatory step. If the assessing officer fails to issue such a notice within the prescribed time, that omission is incurable and the resulting assessment order is null and void. The notice cannot be dispensed with, even if the assessee has cooperated or filed a return. The ITAT applied the binding precedent from Hotel Blue Moon and its own coordinate bench decision in Prem Lata Verma. The tribunal noted that the facts in Rajvir Singh's case were identical. The assessee had filed his original return under Section 139 and explicitly asked the assessing officer to treat that as the return in response to the Section 148 notice. Despite this clear request, no notice under Section 143(2) was issued. Following the Supreme Court's dictum, the ITAT held that this omission vitiates the entire reassessment proceedings. The tribunal reproduced the text of Section 143(2) to emphasize its mandatory nature. The provision states that if the assessing officer considers it necessary or expedient to ensure that the assessee has not understated income or underpaid tax, he shall serve a notice on the assessee. This notice triggers the scrutiny assessment. Without such a notice, the assessing officer has no jurisdiction to proceed with the assessment under Section 143(3). In reassessment proceedings too, once a return is filed in response to Section 148, a Section 143(2) notice is mandatory before any order can be passed. The Revenue attempted to rely on the findings of the Commissioner of Income Tax Appeals and the National Faceless Appeal Centre, arguing that the assessment order was valid on merits. However, the ITAT rejected this contention. The tribunal clarified that a jurisdictional defect, such as the failure to issue a mandatory notice, cannot be cured by any subsequent proceedings or by the lower appellate authority confirming the order. A void order remains void, regardless of its merits. Since the ITAT quashed the assessment order purely on the legal issue of non-issuance of Section 143(2) notice, it did not adjudicate any other grounds related to the merits of the additions or disallowances. Those grounds become academic now. The tribunal made no observations on the factual merits. Consequently, the reassessment proceedings under Section 147 by 144B are null and void, and the assessee's original return filed under Section 139 remains on record as it was, without any scrutiny reassessment. In conclusion, the ITAT Agra bench allowed the appeal of Shri Rajvir Singh, quashing the assessment order under Section 147 by 144B for assessment year 2016-17 solely on the ground of non-issuance of notice under Section 143(2). The decision reinforces that in reassessment proceedings, if the assessee files a return, the assessing officer is duty-bound to issue a Section 143(2) notice before completing the assessment. Omission of that notice is not a curable defect, it strikes at the very jurisdiction. This ruling serves as a crucial reminder for tax authorities to meticulously follow statutory procedures. The primary legal ground was that the assessing officer failed to issue a notice under Section 143(2) after the assessee filed his return in response to the Section 148 notice. The assessee argued that this omission made the entire assessment order invalid for lack of jurisdiction. The tribunal accepted the assessee's explanation for the 40-day delay in filing the appeal. After hearing both parties, it condoned the delay, finding that there was reasonable cause and that the interest of justice required the appeal to be heard on merits. The key Supreme Court authority was Assessee versus Hotel Blue Moon. In that case, the Apex Court ruled that missing the notice under Section 143(2) is a fatal defect that cannot be cured. The ITAT applied this principle directly to the present case. No, the tribunal did not rule on the factual merits of the additions or disallowances. Since the assessment was quashed for lack of jurisdiction, the merit-based arguments became academic and were not addressed. The reassessment proceedings are now null and void because the assessment order was quashed. The original return filed under Section 139 remains on record as it was before the reassessment. The scrutiny reassessment is no longer valid, and no further action can be taken under that reassessment. Thanks for watching this video. You can download the full analysis, case law, and case digest PDF from our website, taxpundit.org. Feel free to write to us or message us on WhatsApp at 932-630-6668 for any assistance. Don't forget to subscribe for more landmark updates.